This video has at least the weight of an affidavit and can be used as evidence in any constitutional court of law. Under penalties of perjury, I swear the following facts and statements are true and correct to the best of my knowledge, so help me God. And help me America expose this good old boy system of corruption. For over 18 years, I, John W. Dobbs, Florida, D.C. number C00618, have been illegally detained based on the actions of a network of officials starting under the watchful eyes of the 9th Judicial Circuit Court of Orange County, Florida, with no end in sight. See case number 48, 2006, CF 15201-0. It's a matter of public record. The discovery evidence establishes that on the early morning of October 25, 2006, around 2 a.m., my ex and I were ambushed by 5 drunk men, strangers, while leaving a strip club called The Dollhouse in Orlando. We'd only been in Florida a day and a half, visiting my children from a previous relationship. We were the only classified African Americans at the club, and before leaving, one of the men asked me, "Where's the hoes at?" because me and my boys want to fuck. In the parking lot, they surrounded us saying, "Get the girl." It only took 4 of them to beat me down to one knee eventually. Cut 6 times, I was forced to use my own 3.5-inch pocket knife to fend them off, injuring 3 of them, killing the 4th or 5th guy to enter the fight. Despite the stand your ground law being over a year old at the time and all of them being convicted felons, the first guy even being on probation, she and I were the only ones arrested, likely because of the wealth and influence of 2 of their families, one being that of the deceased. For the first month or 2, I was held without a single sworn or notarized statement against me. As each of them trying to cover their tracks said they didn't know how the fight started, they got to help a friend and couldn't say for sure which one. Initially, no one said I started the fight. My case docket actually starts with the entry, October 25, 2006, complaint filed, none, followed by my county jail inmate number. The clerk of court was aware I was being held without probable cause, thus illegally. Therefore, the court lacked subject matter jurisdiction and acted where it had no authorization in violation of Chapter 1.01 of Florida Criminal Practice and Procedure, and any statements not sworn to before a person authorized to administer oath that are used to support my detainment amount to not just fraud but fraud in the court. Issues that can be brought up anytime and as many times as is necessary to get to the heart of the matter. So, trying to hide the notice that no complaint was filed to initiate the proceedings, they list my docket entries from end to beginning to confuse people instead of beginning to end as its regular procedure. As every other witness, including security for the club, says it started as a fist fight with me facing multiple opponents. Security's admission to calling police prior to anyone being stabbed means the 911 recordings would contain exculpatory evidence in my favor. Ironically, Florida officials claim the 911 recordings could not be produced due to a malfunction. Even the ones calling the ambulance once they came back and found people stabbed. They wouldn't take me to the hospital like everyone else. Instead, they stitched me up in the county jail where the doctor told me I looked like I'd been attacked by dogs. And the arresting detective David Felon filed in his report that I had no injuries. At the December 22, 2006 adversary preliminary hearing, the first sworn statement demonstrating the crime on my part appears with this man named Andre Blanco saying I started the fight. As if the guy who leaves the strip club with the girl would be so jealous of 5 lonely drunk guys who are all bigger than him in a state where he's a foreigner that he drags his girl into a circle where he attacks them with a pocket knife. His claim that I drove my car to his, jumped out and lunged at him, stabbing him in the face for some unknown reason, but he didn't see the knife and never knew he was stabbed. He only recognized himself as being punched really hard, after which he gets up, runs at me, and admittedly attacks me from behind, is the only statement of facts incriminating me throughout my entire trial court process. This claim was not only contradicted by his prior statements to police and by CSI also, who says our cars were parked 6 parking spaces apart and blood spatter evidence shows the altercation took place at the rear passenger side of my vehicle, but all other witnesses say he approached me and it started as a fist fight. Even his partner Francisco Garte, who attacked me next, says He saw Andre approach me. We started fighting. He's not sure who swung first, but I got in a good punch, and when he saw Andre fall, that's when he attacked by running at me, swinging twice, missed both times, and I punched him in the face before stabbing him. Obviously, if Andre Blanco testifies to running after me and attacking me from behind right after he fell, and Francisco Gate testifies that he ran at me swinging after he saw Andre hit the floor, then it is undisputed that I was under attack by multiple assailants at the same time from the earliest moments of the fight, and that Anthony Villano and the deceased William Troy entered the brawl, compounding my desperation of their own free will, while there is no demonstrable evidence that I used my knife prior to facing multiple assailants. It couldn't even be manslaughter, much less murder, because the slaughter was against me. Even if a judge or jury chose to believe Andre Blanco over everybody else, his statement revealing that he didn't detect a knife prior to attacking with either of his 5 senses makes it unlawful for them to find me guilty of anything more than a simple battery, and every action I take after must be deemed self-defense as a matter of law, especially because he actually says he grabbed me and started hitting me from behind. So how is it I'm sentenced to the max for every charge? 15 years for aggravated battery against Andre Blanco, 15 years for aggravated battery against Francisco Gate, and natural life for the alleged murder of William Troy. Ask every member of the court knows are non-existent offenses when protecting yourself or another is an element. Crimes that never occurred. Sheriff's Deputy Herbert Mercado referred to me as the victim twice at the hearing. Prior to that, during my interrogation, when I asked arresting Detective David Felon what he thought happened, he said you get into a fight with 4 guys, pull out your knife, and go to work. In the interrogation room, when I asked CSI Allison Wright, when I asked CSI Allison Wright if she ever heard of anything like this, she said out of her own mouth, self-defense? Yeah. Yet the law is that they have reason to believe this was a justifiable use of force. They are not even supposed to arrest you. I requested a trial by judge knowing they would have to properly apply the law or bear the burden solely for their incompetence. My request was denied. At trial, the manager of the Dollhouse, Donald Swift, testified that Andre Blanco came back to the club a week later to apologize to him for the incident, but Judge Lisa T. Money asked the jury to leave for that part and instructed him not to tell them. My ex, Deanna Washington, was threatened as an accessory to murder, terrifying her from standing by my side. She somehow mustered the courage to testify that they surrounded and attacked me, saying, "Get her," and their intentions were to take her away from me. In closing arguments, State Prosecutor Kimberly Laskoff changed her theory of guilt from her opening argument that I brought a knife to a fist fight, starting with Blanco and I in a fighting stance, which no one testified to another confusing fabricated theory, again knowing not even the alleged victims testified to, because all the laws and evidence were on my side. She fabricated events and conversations that never occurred, therefore infiltrating the jury's mind as a witness. Though all the alleged victims testified they didn't know any of them were stabbed or bleeding until the very end of the fight, which they say lasted around a minute and a half, she said they only joined the fight to help each other after they saw their friends bleeding and falling to the ground. She said my expressed desire to protect my girl was a magic trick I was trying to pull on the jury. Yet she told them the fact that the alleged victims couldn't get their story straight was evidence they didn't get together and make it up. She said Deanna was egging me on, asking me to do something about an insult that never took place. She said there's no way I didn't commit murder, and made statements like, quote unquote, "That's not what we made the law for," giving the impression she actually helped make the stand your ground law, trying to rob the jury of its pardoning power. She said I held the knife in an underhanded way, different from how I described, though the truth is they were too busy attacking to notice my knife or be concerned for each other. And despite club security Justin Idell testifying he saw one of them come at me from behind, describing me being hit with something shiny, her excuse for me being cut 6 times was I cut myself, also telling the jury they didn't have any weapons despite the razor found on the scene. She actually says, and I quote, I submit that he cut, and I quote, pardon me. She actually says, and I quote, I submit that he held the knife like this and put on a demonstration. And also, I quote, I submit that he cut himself and put on a demonstration. But the transcripts have been altered to have her as saying it's the state's position that he held the knife like this, and it's the state's position that he cut himself. So her statements wouldn't be automatic grounds for reversal on appeal. So much of the transcripts have been altered to protect the conviction. They say they never recorded the trial by audio or video. Incarcerating us is a ruthless business, and out here prosecutors practice ruthless tactics in order to convince you as a juror that this person you do not know deserves the punishment they aim to deliver. A common strategy, which is actually illegal amounting to prosecutor misconduct, is playing false witness, making personal comments about the defendant's guilt or innocence or disputed facts, because the average juror will no longer view it as the defendant being tried by a system seeking the truth of the matter, relying on their opinion of the evidence. It becomes a question of whether you believe the credibility of the defendant or the prosecutor themselves, whose integrity has personally never been questioned or subjected to cross-examination. The average juror would then ignore the evidence and think, why would they lie, and not be able to find a single reason. I want to petition that defendants are allowed to call their prosecutors to the stand to examine whether any motivating factors other than guilt or innocence are at play. So, anyway, they force a trial by jury, but if you question the jurors, you'll find only one came into the courtroom in my presence to read the guilty verdict. No matter what the transcripts say about them all being and coming in and being questioned, I never saw any of the other jurors ever again after they went to deliberate. Since then, I've been subjected to an indefinite imprisonment. On direct appeal, when I told my public defender, Kevin Holtz, all the evidence in my favor in a phone conversation, he said, and I quote, "I can argue this thing where they have to release you, but you know they're not going to let you go." In our last phone conversation, when I explained that the charging information wasn't even signed or notarized, which I tried to explain it at the adversary preliminary hearing, he simply says, "What if he signs it? What if he signs it?" This was 2008, 2 years after it was filed. So I fired him and represented myself to argue my issues. And when he sent me the trial court records, he sent a signed, notarized, backdated version. I found numerous misleading jury instructions planted around the stand your ground law to make the jury believe I had to back down and retreat before I could lawfully stand and fight. A couple even deemed fundamental error by Florida courts, such as the extra comma deemed entirely versus state to be error because it causes the jury to believe you don't have the right to stand your ground against non-deadly force. Then there's the error complained of in Montgomery versus state, where the extra element of intent makes it harder to find the defendant guilty of manslaughter than second-degree murder, when the opposite should be true. There's the error in calling the initial provocation instruction an initial aggressor instruction without letting the jury know that it means aggressor, because the word provoke could mean to irritate or annoy, and not necessarily aggressor in layman's terms. Also, there's the necessity instruction, which concedes guilt and makes it impossible for the jury to find me not guilty unless I prove the harm I prevented was greater than the harm I caused. So I can no longer meet force with equal force. All this in violation of both the Florida and U.S. constitutions. Nevertheless, I have been denied on every corner, despite misleading jury instruction, despite insufficient evidence, despite the weight of the evidence on my side, despite selective prosecution, despite prosecutorial misconduct, despite the prosecutors knowing use of perjured testimony, despite fraud upon the court, despite even the court's lack of subject matter jurisdiction, issues that cannot be time barred. These denials never have an opinion on the points and are never explained except to say the conviction or denial before supports the denial now. The repercussions of my potential lawsuit has mysterious individuals intimidating both supporters and other officials. We paid George Rears and his paralegal/investigator Keith Harris to present my arguments to Orlando's Conviction Integrity Review Unit back in 2022. They have not returned our calls for the whole of 2024. Every official, clerk, or magistrate, or otherwise, who says they will work within the law to get justice has the case taken from them by a supervisor who will deny it or dismiss it. From court to court, I run into a chain of interchangeable corruption, demonstrating that a secret union or whatever form of judicial gangbanging has infiltrated multiple facets of our justice system. I'm currently held in Florida Department of Corrections on redacted paperwork and have been the subject of a vicious mail and phone call interference campaign where I never received hundreds of letters from supporters, including friends and family who say they've written me over 15 times, even taking pages out of sealed legal mail I've sent or not mailing it at all. Also, 9 times out of 10 not allowing my phone calls to go through, telling them I hung up, or telling me they disconnected or wouldn't accept my call. Now not even delivering my responses on the JPay Securus e-messaging service, all to discourage you guys from supporting me. The bottom line is, I'm a political prisoner illegally detained with all the laws and evidence on my side over 18 years, just not the law enforcers, all because of my race and socioeconomic status in the face of wealthy families and big business as Orlando becomes America's tourist capital, and Judge Lisa T. Munyon, who despite the law and the evidence sentenced me to die in prison because she became the chief judge for the 9th Judicial Circuit and thus the go-to judge, criminal or civil, for the whole city. This case is the epitome of the systematic oppression plaguing minority families since before the Civil Rights Movement. The abundance of violations makes it the ideal catalyst for change. So at the very least, promote the video or cower and turn a blind eye as you or your friends or loved ones fall victim and our youth say, damn the law, because they don't enforce the laws that protect us, just the ones that screw us over. There's an insidious element in our justice system bent on misdirection and having the public opinion always view us as the bad guys, never the heroes, unless we work for them. That's a monkey wrench in their secret favor for a favor system. They'd rather make tourists disappear than publicize the threat some of their good old boys pose. These statements being sworn to as prima facie evidence which must be disproven, not just denied. God bless the activists. God bless America. Open the gates. Free King U. Yeah, they stand as prima facie evidence. That means that basically, it has the weight of where it has to be disproven in the court of law.